Hello everyone, welcome to the example. This is the first video of the IPC series where we'll be looking at the basics of law of crimes. In this video, we will be studying some of the important criminal law maxims that you need to know not only as a law student but also as a criminal lawyer or even a judge if you aspire to be one. Then we will consider the essential elements of a crime. Coming to the first legal maxim, that is actus reus, which means an overt guilty act. This act results in preparation, attempt, or the actual commission of the offense, depending on what act it is. The second legal maxim is mens rea, which means guilty mind. Now, both mens rea and actus reus are sine qua non for the commission of a crime, which means they both are essential ingredients when it comes to punishing an offender for commission of a crime. There is one exception though. Mere actus reus is punishable where the nature of liability is strict or absolute. We'll study these concepts of liability in detail in the near future. The third legal maxim is actus non facit reum nisi mensit rea, which means for a person's act to be guilty, the person must have a guilty mind too. A good example would be of section 80 of the Indian Penal Code, which is a general defense of accident. Let's say a person is trying to shoot a bird with a rifle, but accidentally the projectile, that is the bullet, gets deflected from a tree, causing harm to another person. In this case, the person shooting shall not be liable because though he has committed a guilty act, there is absence of mens rea, that is guilty mind. The fourth legal maxim is actus me invito factus non est meus actus, which means an act I have committed which is against my will is not my act. So, for example, Section 85 of the Indian Penal Code 1860 is a general defense of involuntary intoxication. So, let's say an intoxicating substance is administered against a person's own will, or he has no knowledge of the intoxicating substance, and he commits an offense subsequent to such intoxication, then he shall not be liable for the same. The fifth legal maxim is mala in se, which means an act or a thing which is inherently wrong. So, for example, Section 376 of the Indian Penal Code prescribes punishment for rape. So, rape is something which is inherently a wrong act. This is contrary to mala prohibita, which means an act is wrong merely because it is punishable by law. Now, it could be debatable whether it is inherently wrong or not, but it is punishable by law. The act is not inherently wrong. So, for example, we had Section 497 of the Indian Penal Code 1860, which prescribed punishment for adultery, which was struck down in Joseph Shine versus Union of India. Now, the morality of adultery could possibly be debatable, but we can agree on one thing that a lot of people believe it is not morally wrong, which means it was not mala in se, but it was mala prohibita, which means it was not inherently wrong, but it was wrong because it was prohibited by law. Now, dolus means an act done without good conscience, and culpa means fault. Nullum crimen sine lege means no crime without law. So we have this personal data protection bill which has recently been introduced in the parliament, which actually puts some restrictions on how our personal data which has been collected by third parties is used, for which we don't have a legislation right now. So let's say there is an act for which there is no legislation which prescribes a punishment. Okay. Let's say you visit a restaurant and they collect your data, which they later sell to the third parties. Now you cannot take any action against them because there is no such crime prescribed by any legislation, which means there is no crime without law. Nulla pena sine lege, which means no punishment without law. So this legal maxim means that if there is no punishment prescribed for a particular act, then that person who commits that act cannot be punished. Though there are certain exceptions to this, one of the exceptions I would like to point out is Section 66A of the Information Technology Act of 2000, which prescribes punishment for sending offensive messages. Now, many courts have taken the view that no FIR should be filed under this section 66A of the IT Act 2000, and no person should ever be prosecuted for the same either. So this is one of the cases where punishment is prescribed by the law, but the person is not being punished because it is struck down by the courts. Now coming to the elements of crime, the first element, the most essential element, is a human being. Though there could be some exceptions to this, for example, if you look at various legislations protecting the rights of animals, or even section 377 of the Indian Penal Code, under which a person can be prosecuted for bestiality. Second one is mens rea, which we have already looked at. Third one is actus reus, again, which we have already considered. Now, fourth one, the most important one, is injury. Now, this injury could be to any person or property. Now, actus reus, that is a guilty act without injury, would be mere preparation or an attempt. We will look at this when we consider the stages of crime. But even if there is no injury, an attempt or mere preparation can also be punishable. There are a few exceptions to this, which we will consider at a later point. That is it for today. Thank you so much for watching. I hope you enjoyed the video. Don't forget to share it with your friends. Comment down below if you have any suggestions, and don't forget to subscribe to our channel to stay updated with our latest videos. Thank you.